This is Barry Zalma on insurance. I am an attorney who has retired from the practice of law and now spend my time as an insurance claims consultant and expert witness, an author on insurance matters, and a producer of these videos. Today I'd like to talk about the fact that ethics is essential to the business of insurance, and the reason for the doctrine of Uberrimae Fidei, Latin for utmost good faith. Ethics is a process of systematically applying, using, defending, and recommending concepts of right and wrong behavior. Ethical behavior is required of both parties to a contract of insurance for the system to work. If any party to the insurance contract acts unethically, the ability of insurance to work effectively and profitably will fail. Ethics is actually the essence of insurance. Since insurance was first created, it has been a business of utmost good faith. As a result, the insured and the insurer are expected to treat each other ethically. Insurance was created over 1,000 years ago to spread risk from individuals to multitudes. Spreading the risk in fair, ethical, and honorable manner from one person to another is the basis upon which the system of insurance was founded. The insurance contract, since modern insurance was first created around the 17th century, it was founded upon the concept of Uberrimae Fidei. The Latin phrase is used to express the principle that a contract of insurance must be made in perfect good faith, with neither the insurer nor the insured concealing anything from the other. In the case of insurance, both the insured and the insurer must observe the most perfect good faith towards each other, so that the insurer understands the risk it is asked to take, and the insured understands the risks accepted by the insurer. Insurers and reinsurers are dependent on utmost good faith, which may be viewed as a legal rule, but also as a tradition honored by ceding insurers, reinsurers, and insurers to their insureds in their ongoing commercial relationships. Uberrimae Fidei has its roots in British jurisprudence. The doctrine has historically been applied to all insurance contracts issued in or to be performed in the United States. The doctrine of utmost good faith was stated by the U.S. Supreme Court dating back to 1828. The doctrine of utmost good faith imposes the highest duty on parties to an insurance contract to disclose facts that materially affect the insurer's risk. Several federal cases have applied the duty of Uberrimae Fidei in the marine insurance setting, applying the doctrine more strictly than courts do in property, casualty, life, health, or disability insurance. Under marine insurance's interpretation of Uberrimae Fidei, any failure to disclose a material fact not known by the underwriter that is or should be within the knowledge of the insured party is grounds for rescission of the policy, even if the omission or misstatement is the result of the insured's mistake, accident, or forgetfulness. In the marine setting, the insured is required to disclose everything that is material to the insurer, even if the insurer does not ask about the issues that are material and that the insured knows are material. Not all federal courts apply the Uberrimae Fidei doctrine to marine insurance policies, but most do. The doctrine of Uberrimae Fidei, the highest degree of good faith, provides that failure by the insured to disclose conditions affecting the risk of which he is aware makes the contract voidable at the insurer's option, and it will be found to have never existed. Consider the U.S. Supreme Court decision of Sitch versus Metropolitan Life, a 1928 decision that is still applied as good U.S. law. Insurance policies are traditionally contracts of utmost good faith, and a failure by the insured to disclose conditions affecting the risk of which the insured is aware makes the contract voidable. Similarly, misrepresentation or concealment of material fact by the insurer allows the insured to declare the contract void at the insured's option because the duty of utmost good faith is mutual. The majority of courts faced with the application of Uberrimae Fidei to a marine insurance policy have found that utmost good faith applies. Insurance, in fact, cannot operate without the ethical doctrine of Uberrimae Fidei. And under that doctrine, the insured in a maritime insurance contract is required to disclose to the insurer all known circumstances that materially affect the insurer's risk, the default of which renders the insurance contract voidable. Under the doctrine of Uberrimae Fidei, the parties to a marine insurance contract must accord each other the highest degree of good faith. This duty of good faith requires the insured to disclose to the insurer all known circumstances that materially affect the risk being insured, like the captain of the vessel has never been a captain before and has only been a deckhand, or that there is a bilge pump that doesn't work, or that there are no motors that are operable on the vessel, or that it simply has a continuous leak in the hull, or that it is so rusty it is being held together by bits and pieces of glue. The age-old federal marine insurance doctrine of Uberrimae Fidei governs the argument and provides the controlling federal rule even in the face of contrary state authority. Because the insured is in the best position to know of any facts that may be material to the risk, the insured is obligated to disclose those facts to the insurer, regardless of whether the insurer makes a specific inquiry about the facts. Uberrimae Fidei reflects an enlightened moral policy based on the presumption that the party procuring insurance is not in possession of any facts material to the risk which he does not disclose. Indeed, it is the duty of the insured to place the underwriter in the same situation as himself. Under the federal common law doctrine of utmost good faith, a failure by the insured to disclose conditions affecting the risk of which he is aware makes the contract voidable, and an insured who conceals or misrepresents a material fact commits fraud, which avoids the policy and is a clear breach of the ethical obligation of the insured. Fraud, by definition, is an obvious breach of the contract and the implied covenant of good faith and fair dealing. It is ethical obligation of the insured to truthfully and fully advise the insurer of the risk the insured is asking the insurer to take. Failure to do so, even if there was no intent to deceive, is sufficient to allow the insurer to rescind the policy if the insurer was actually deceived. In ancient days, before telephones, telegraphs, and email, a ship could have been insured that had sunk months before because the news hadn't arrived to the insured. Even so, there could be no coverage for such a loss. It is sometimes difficult for a court to determine which of the considerations influence the classification of insurance contracts, but at least the insurance considerations have been referred to as Uberrimae Fidei in England and in the United States. The two countries, however, are not in accord in their interpretation of Uberrimae Fidei. Nothing is better established in the law of marine insurance that a mistake or commission material to a marine risk, whether it be willful or accidental, or result from mistake, negligence, or voluntary ignorance, avoids the policy. Concealment in the law of marine insurance is the failure to disclose any material fact or circumstance in relation to the subject matter of the contract which may increase the liability to loss or affect the risk or obligation assumed, and which is in fact or law within or ought to be within the knowledge of one party and of which the other party has no actual or presumptive knowledge. In the case of marine insurance, the insured must disclose all facts material to the risk, and is in default of such a duty, the contract can be avoided by the insurer, and the policy never attaches to and is void for the reason that the risk assumed is not the one intended to be assumed by the parties. In the leading English case of Carter versus Beam, decided on the 11th of May, 1766, Lord Mansfield declared that even an innocent concealment of a material fact made the contract voidable, saying that the question therefore must always be whether there was, under all the circumstances at the time the policy was underwritten, a fair representation or a concealment fraudulent if designed, or though not designed, varying materially the object of the policy and changing the risk to be run. In that case, of course, he found there was no misrepresentation, and that the underwriter even knew more about the risk than the person seeking the insurance, and Lord Mansfield forced the insurer to pay. The doctrine of Uberrimae Fidei obligates the assured to volunteer information which might have a bearing on the scope of the risk assumed, and the failure to do so will allow the insurer to avoid the policy. So when dealing with marine insurance, and when dealing with insurance of any kind, depending on the location, where the state applies the marine rule to the law of rescission, it is essential that the insured and the insurer treat each other fairly and with utmost good faith, and disclose everything needed to be disclosed fairly and completely, so that there is no confusion as to what risk is being insured and as to who is being the person seeking the insurance. This video was adapted from my book, Ethics for the Insurance Professional, 2nd edition, which is available as both a Kindle book and as a paperback from Amazon.com. and from my website with detail about it and all of my other books available as Kindle books and paperbacks from my website, zalma.com, by clicking on the link to the Insurance Claims Library. If you found this video to be of use to you, please refer it to your colleagues. It's free. And please subscribe to my YouTube channel, my Rumble channel, my blog, so that you can be informed of all future videos and blog postings. Thank you for your attention.